Coda TV, reconciling humanity to the source. Stay blessed.
The minimum wage are set by an employee's contract, the award, or the enterprise agreement. So you may have extra pay, and that depends on what kind of job you are doing.
The responsibilities.
So in the case of when you are doing an overtime, payment for working after the end of regular shifts. You know, if you are supposed to be working 8 hours a day, and then on that day you are supposed, they just said, oh, because of these issues you are going to be working more than 8 hours, then that's overtime, and then you must be paid for that. And then there are also penalty rates, higher rates of pay for working night shifts, for working early shifts, okay, for working on weekends, because these are times that you have to be resting. So if you're going to be giving off to be working during weekend, during night, during early morning, then the penalty rates, they differ.
And even public holidays is another thing.
They differ. So these are things you need to know. You need to know what time of the day you are working. Okay, if you are working beyond the set period that you are supposed to be working, then some penalty rates apply. Also, you may be given allowance, like extra money for the cost of doing a job. Example, an allowance for the meal, allowance for uniform, for the tool, or for travel. There are some people who are working, and then the at the end of the day, the employer just deduct money from their pay.
Just like that.
You know, just deduct money from their pays. You need to. Some workers, it's an allowance that they may be entitled to, and you have to reach out to be able to understand. You know, you have to understand your contract and understand what kind of entitlements apply to you. So for underpayment, which is a very big issue in Australia, because many are exploited, and migrants, a lot of people are being underpaid in this country, though they know what the minimum wage is. They're still receiving less than the minimum wage, and they don't want to speak out. The truth is, it's unlawful for an employer not to pay you or to underpay you for your work. It is unlawful for that employer not to pay you for the work done, or to be paying you less than you are supposed to be paid for the work that you have done. And claims for non-payment or underpayment can be made up to 6 years from the date you were underpaid. So for instance, if today you work for an employer and that employer unpaid you, 6 years from today you could make the claim for that underpayment. And so you could look back to all the jobs you have done
and roll back,
and go, if in the event that you have been underpaid, speak to a lawyer. There are free help available to help you, and you can claim for those payments, because it is unlawful for an employer or for the boss to not pay you for the work done or to underpay you. Now again, it's important that we keep all pay slips and notes about any verbal agreement, because that will be the evidence. Imagine you've worked for somebody 3 years ago and you had no letter, but then it was through a verbal. If you have a diary, you know, you keep a note of your contract verbally, you could claim. So it's good to keep a work diary about shifts, or use the Fair Work Ombudsman record your hours app. This is an application you can get
from Android.
Android or iPhone. The Fair Work Ombudsman record your hours app. You can keep it. It takes note of when you went to work. Like, you can take note of your shift, and it's very good just in case there is an issue of underpayment years to come. This keeps note, and it will help to be able to fight your case for you. And then again, you can use the Find My Award online service to find the award that cover your employment. So for instance, you can go online, and then you put in what type of worker you are, and that will be able to tell you, okay, then I'm entitled to this award, I'm entitled to this and that will keep you abreast with what you're doing. So right when your work ends, want to continue and look at laws about the end of employment. If you're working for an employer who says, now it's all right, I don't want your services again, what are your rights? See, employer says, I don't need you anymore, or you are fired.
Wow.
What are your rights? So right when your work ends. Now, every worker, and I keep saying, no matter your visa status, you should get written notice of termination.
Yeah.
And you should be able to work out the notice period or be paid for the same time. And this is not for casuals anyways.
Yeah, that's the problem.
Yes, it's not for casuals. Then again, so if you're going to be employer expects you not to work again, you should be given a written notice of termination.
Okay.
Yeah. And then again, another right is that payment for leave. Yeah. Payment for leave. You have a right to be paid for any accrued annual leave. You have the right to be paid for long service leave. That is when you work for more than 7 years and over for a particular organization or an employer. Then you have the right to be, to be paid for the leave.
Yeah. Okay.
When you accrue the leave, you are supposed to go on leave, and they said, oh, because of we are understaffed, please
stay back.
Stay. If it happens more than 7 years, you have the right to be paid all the accrued. Yeah. And then there's this called redundancy pay. As if it's relevant, you need to be given redundancy pay. You may have the right to redundancy pay if the boss no longer requires your position. It's the boss who doesn't require your position. It's not you who said you don't want to work again. So, and that again, not for casuals. So, what amount of notice must you be given? And then we're saying that if they want to terminate your work, they need to write to you. You need to be given that written notice. Yeah. And the period of continuous service. So for instance, if you work for 1 year for organization, then you must be given a 1 week notice. That's if they want to terminate you. If you work between 1 to 3 years, then you should be given 2 weeks. If you work more than 3 to 5 years, then you should be given 3 years. So that works based on the number of years that you've been working for that organization.
All right.
So in the event that none of this has been satisfied, you just wake up and your boss tells you you are fired, then there is an issue. So the question is, was your dismissal unfair? And there are things that must certify that, okay, I have been terminated unfairly.
Yeah.
Or you've been terminated fairly. If you are dismissed, what we call you are fired from work.
Just like that.
Fired. You have the right to be told why you are losing your job. That is your right. Whether you are a migrant or not, it's your right to be told why you are not supposed to be working again, why you are fired. You have the right to be given a chance to say why you shouldn't lose that job.
Okay.
You should be given a fair ground. I don't want to lose my job. It's your right. You have that right. So, and you also have the right to be given a fair reason for ending your job. What is the reason? And is the reason fair? Now, should you be fired unfairly, which we call it like unfair dismissal, then you have only 21 days from the date you were dismissed. And this, all workers need to take note of this. It's a very short time, 21 days from the day that you were dismissed to make a claim.
Okay.
That is what the employment law says, and that is why we are speaking to the community. There are many people who employers have just sacked them from work. They've lost their job, and because they don't know this, they stay home a month, after a month, years before they want to make a claim. It's not possible. You have 21 days, and so if you find yourself to be dismissed unfairly, and it is not you to determine whether your dismissal was unfair or fair, you need to speak to a legal person
to let you know whether it was fair or
exactly unfair. Because if, as long as your job has ended, there are things that need to prove that you were unfairly dismissed or you were dismissed fairly. Okay. In the event that you feel you were treated unfairly, then speak to a lawyer, seek help, reach out. The Migrant Employment Legal Service, there are lawyers there who are ready, free lawyers, to help the community, help migrants, because they realize this is an issue in the country
that needs to be addressed.
Yes. And so you have 21 days to make a claim. You have 21 days to make the application. You have 21 days. And so we need to act fast. If there's somebody who has been dismissed unfairly, you have 21 days. And that I keep stressing. 21 days from the date of dismissal. So if you lose your job for an unlawful reason, you may also be able to make a general protection claim. Okay? You may be able to make a general protection. You cannot lose your job because you made a complaint or for any other discriminatory reasons.
Okay.
So if there is something like that, then you can make a general protection. A general protection claim, like it protects you, so you don't lose your job. Right. And that's a claim you can make. And if you've lost your job, you only have 21 days. And this is a very, very good and important information they want us to pass to the communities. Many people have lost their job unfairly, and because they missed this date,
they couldn't help them.
There is no help. So please, immediately you are issued that letter, you are fired, or verbally told you are fired, don't come to work, then you have 21 days, and that's why you have to act very fast. Now, discrimination at workplace. Every worker, and I keep saying, no matter your visa status, whether you are a student, an international student, whether you are permanent resident, employers cannot take action against you based on your gender, based on your sex, based on maybe your sexual orientation, based on your race, the color, maybe I'm a black, I'm a white. No. Based on your physical or mental disability, based on your age, relationship status, family or careers responsibilities, religion, maybe I'm not a Christian, maybe I'm a Muslim, political opinions. Employers should not take any action against you based on any of these. It is against the law.
So can we rather than say that the only thing they can use that against you, the only reason is maybe if you think you are of a certain sexual orientation but you want to use it against somebody, then they will not accept that. Because if your employer did not treat you unfairly based on what sexual orientation you have, then as staff, amongst staff, you cannot also use it against somebody, or you can't influence someone.
Exactly.
That is where there can be a problem. Then they can act on against you.
Sexual harassment.
That's right.
As a worker, you are not supposed to harass anybody sexually or bully anybody at the workplace.
That's right.
It's against the law. And as an employee, you should not be bullied at the workplace. You need to speak up. In Australia, it's found out that from the training, we realize most people don't speak out. They are sexually harassed. They are bullied. They are not speaking out. So as long as employers cannot discriminate based on any of these, you as an employee you also have certain responsibilities and certain things you need to be doing, those things that you should not be doing at the workplace. So it is unlawful to be bullied or harassed at work. What is bullying? Now, bullying occurs when a person repeats